All right, welcome everyone. Welcome to the revision marathon of the special provisions of Contract Act. So in this session we are going to revise contract of indemnity, guarantee, bailment, pledge and agency. It's going to be a one-shot revision where we cover all the special provisions of Contract Act. As you are aware that section 1 to section 75, they cover the general provisions of contract which are applicable to all kinds of contracts. Section 76 to 123, it related to sale of goods, and section 124 to 238 relates to special provisions. So what we are going to revise are the special provisions of contract. So let us begin our first discussion, that is of indemnity and guarantee. If you see my concept book, you will find a chart where I have listed all the section numbers. They are all very important for exam because question has been asked on almost all the sections. So you need to study the section numbers as well as the provisions. Let us discuss the contract of indemnity first. Then we will discuss the contract of guarantee. It's a very quick revision. So let's get started. Now, what is a contract of indemnity? Indemnity means to compensate or to make good the loss. To indemnify means to compensate. Insurance is a very good example of contract of indemnity. Although contract of insurance is not covered expressly by the definition, but yes, it is also considered as a contract of indemnity. Now, indemnity means to indemnify. This is a very good example for a contract of indemnity. Now, the government has sent Mr. X abroad for further studies. All expenses paid by the government. Now, if the government is spending so much, they will want that X should come back and work for the government. So they enter into a contract with him that you will return and you will work for the government. If you fail, you will work for the government for 3 years. And if you fail, then you will pay compensation. So this is nothing but a contract of indemnity, wherein X is promising to indemnify, that is compensate the government in case X fails to work for those 3 years. So this is a type of contract of indemnity. S has applied to the company for a duplicate share certificate, claiming that I lost the original share certificate due to fire in my house. Now, how can we be very sure that S is telling the truth? It is possible that he is lying. So the company tells him that I will issue a duplicate share certificate provided you provide an indemnity. In case someone else is also claiming to be the owner and we are forced to pay him compensation, then we can recover that compensation from you. So this is also a contract of indemnity. So the duplicate share certificate will be given by the company provided S gives indemnity. It's a promise that in case someone else claims to be the owner by showing the original share certificate, then I will bear the compensation. So on the basis of that indemnity, the company will give him a duplicate share certificate. Let's read the definition of a contract of indemnity. Indemnity is defined under section 124 of the Contract Act. As per section 124, indemnity is a contract by which one party is known as the indemnifier. He promises to save the other, also known as the indemnity holder or indemnified. So one party is promising to save the other from loss caused to him, that is the other person, either by the conduct of the promisor himself or by the conduct of any other person. If you see the definition, it is only covering the loss which is caused by persons, either the promisor himself or any other person. But nothing is mentioned about the loss caused due to natural causes or maybe fire, earthquake, etc. Law says that although the definition is very narrow in its scope, contracts of insurance are still considered as contracts of indemnity by applying the principles of good faith, justice, public convenience. So, yes, insurance is also a contract of indemnity. So, what are the various parties involved? So, we have the indemnifier, the person who promises to make good the loss, and we have the indemnity holder, the person whose loss is being made good. What are the rights of the indemnity holder covered under section 125? Just as section 124 is very narrow in its scope, section 125 is also very narrow in its scope. Section 125 covers only that loss which is caused by the case filed. So any amount which the indemnity holder is forced to pay in a suit. So all the losses which are caused while filing a case, only that can be recovered. So the damages which you have to pay at the time of filing a suit, or all the costs which you have been compelled to pay in bringing the suit. Any cost may involve the cost paid to the lawyer or the court charges, etc. Any sum which may have been paid under the terms of the compromise, like principal amount or interest. So yes, even this is very narrow in its scope. But law says that the damages under section 125, they are not very exhaustive. The indemnity holder can claim damages other than these also. What kind of question is asked generally? A theory question is asked on section 125. Next, let us discuss few other points relating to indemnity. Now, a contract of indemnity may be expressed, that is expressed in words, oral or written, or it may also be implied, it may be understood from the act or the conduct of the parties or circumstances of the case. One very good example is given in my book. Y was instructed by X to sell the goods in auction. Okay, so X instructed Y to sell certain goods in auction. So Y sold the goods, but later on he realized that X was not the true owner of the goods. Now, if X is not the owner, then the sale will not be valid. Z, the true owner, took action against the auctioneer. Why did you sell my goods without my permission? So in this case, Y was forced to pay compensation to Z. Now, is it the fault of the auctioneer? No. X was not the owner. This fact was not known to the auctioneer. Z, the true owner, claimed compensation from the auctioneer. Auctioneer will pay, but he is entitled to claim that from X. X will have to compensate Y for whatever damages Y has paid to the true owner. This is understood. It is an implied contract of indemnity. It's implied, it is understood. Since it is a contract of indemnity, all the essential elements of a valid contract must be present. This is very interesting. When does the liability of the indemnifier commence? The liability commences as soon as the liability of the indemnity holder becomes absolute and certain. Now, who is an indemnifier? He is the person who promises to make good the loss. Indemnity holder is the person whose loss is being made good. Now, when does the liability of the indemnifier commence? As soon as the liability of the indemnity holder becomes certain. Absolute means I know the exact amount and it becomes very certain. That is the time when the liability of the indemnifier commences. Now, to give you an example, X promises to indemnify any loss which Y has suffered in filing a suit against Z. So X told Y, Ari, don't worry. Whatever loss you are expected to pay, I will compensate it. Don't worry. File a case against Z. So Y filed a case against Z, but he lost. The court orders Y, sorry, yes, the court orders Y to pay 25,000 rupees as damages to Z. Okay, so Y lost and he was forced to pay 25,000 rupees as damages to Z. Now, this has become absolute and certain that he has to pay. X cannot tell Y, Arif, first you pay and then recover it from me. That loses the very purpose of indemnity. As soon as the loss is determined, X will pay the money to Y and Y will then pass on that amount to Z. See, X had promised to indemnify, he had promised to compensate Y. So, if you are promising to compensate, you are the indemnifier. Your liability will commence as soon as the liability of the indemnity holder becomes absolute and certain. As soon as the court determines the charges, you will have to pay that to Y and Y will then pass it on to Z. You cannot ask Y to pay first and then claim it from X. And that will lose the very purpose of indemnity. So guys, these are the main important points of indemnity. There are only two sections, 124 and 125. Not very important for exam, but yes, a few questions have been asked in the past, like on this. Then on insurance, they have asked a question. Next, let us revise the concept of guarantee. But I have a few examples to help us first revise the meaning of guarantee and to understand the concept of guarantee. Now, there are three examples. We had already discussed them during the lecture, but let's revise them because they are very important for us. This will actually help us to recall the concepts of guarantee. Now, a creditor agrees to give goods to the debtor on the condition that he provides a guarantee. What if debtor defaults? So, creditor doesn't want to lose his money. So, he tells the debtor to bring someone who will pay in case the debtor defaults. He's saying it's a very high value transaction. You're asking me to give you goods worth rupees 10 lakh on credit. So you bring someone who will guarantee that I will receive the money, that you will pay. So creditor agrees to sell goods worth rupees 10 lakh to the debtor, provided debtor provides a guarantee. So debtor tells his friend, will you give guarantee on my behalf? S agrees. So S gives guarantee to the creditor. Don't worry, debtor will pay. If he defaults, I will pay. So so S gives guarantee to the creditor. This is known as a contract of guarantee. S is not doing some kind of charity work over here. He will first pay and then later on recover that money from the debtor. Since there are three parties, there are three contracts. The first is between the debtor and creditor. This is the primary contract, main contract. If the debtor defaults, creditor can recover the amount from the friend. Okay, now let me also highlight the parties for you. The person who gives the goods on credit is known as the creditor. The person to whom the goods are given is the debtor. The person who gives the guarantee is the surety. Debtor is also defined as a person on whose behalf the guarantee is given. So in this case, there are three contracts, there are three parties. The person to whom the guarantee is given is the creditor. The person on whose behalf the guarantee is given is the debtor, and the person who gives the guarantee is the surety. So this is the primary contract between the creditor and the debtor. There is another contract between the creditor and the surety. Now, if the debtor fails, if he fails to pay the creditor will recover the money from the surety. Surety will pay and then later on recover it from the debtor. It's an implied contract that I have paid your obligation. Now you will have to reimburse that money. So there is an implied contract between the surety and the debtor. What is the consideration for the debtor? For the debtor, the consideration is goods. For the creditor, consideration is 10 lakh rupees, money. But what is the surety getting? He doesn't get anything tangible. But the fact that my guarantee has allowed debtor to receive the goods on credit, the benefit received by the debtor is enough consideration for the surety. So what are the consideration for the surety? Benefit received by the debtor as a result of my guarantee. If I had not given the guarantee, the debtor would have not received the money. He would have not received the goods on credit. So the benefit received by the debtor as a result of guarantee is enough consideration for the surety. So there is consideration for all the three parties. It is a valid contract. So there are three parties in a contract of guarantee. The guarantee which is given for the good conduct of a person is known as fidelity guarantee. You're guaranteeing the good conduct of a person, that is known as fidelity guarantee. So there are three parties, there are three contracts. Now, what are the essential features of a contract of guarantee? Essential features include that it is a tripartite agreement. Tripartite means there are three parties, there are three agreements. We need the consent of all the three parties. When all the three agree, only then it will be a valid contract of guarantee. We need consent of all the three. Mostly a theory question can be asked on this. Existence of liability, you can give a guarantee only for an existing debt. Like X gave loan to Y in the year 2000. Y has not repaid the money until 2003. Can I say that this debt has become time barred? In 2003, Z is giving guarantee. Is this guarantee valid? Law says no. This debt has already become time barred. It is legally not recoverable. When you cannot file a case, it is legally not recoverable. The guarantee is also not valid. You can give a guarantee only for a debt which is enforceable by law. This is legally no longer recoverable. It's no longer enforceable. So Z's guarantee is invalid. Since it is a contract of guarantee, all the essential elements of a valid contract must be present. But there are certain exceptions. Like we are okay even if the debtor is incompetent to contract. Like see this. There are three contracts. We are allowing the debtor to be a minor. So if the debtor is a minor, this primary contract will be void. Creditor cannot recover anything from the minor debtor. Then the creditor will go to the surety. Here there is no minor. So surety will pay the creditor. After paying, surety will not be able to recover that money from the minor debtor because he is a minor. So in the end, surety will pay, but he is not entitled to recover that money from the debtor. So it is as if it is his personal liability. The guarantee given for minor is valid. Guarantee is valid. Okay, so the guarantee given by the minor is valid, but the agreement between the debtor creditor and the surety along with the debtor is void. So it is as if it is a personal liability of the surety. The main agreement is void, but the guarantee given for the minor is valid. So the surety will pay, but he cannot recover that money from the debtor. So we are allowing the debtor to be a minor, but then everything will fall on the surety. So all the essential elements of a valid contract must be present. There should not be any misrepresentation or concealment while obtaining guarantee. Section 142 and 143. 142 talks about misrepresentation. Here it is not innocent. Misrepresentation by the creditor means you are giving some wrong facts with your knowledge and assent, or there is some concealment or silence as to the material circumstances. So can I say in section 142 you are saying something which is false, and in the next section, that is 143, you are concealing, you're not saying anything. So this talks about saying something, and this is about not saying something. So here the creditor is misrepresenting the facts and obtaining guarantee, then that guarantee is invalid. In the second case, the creditor is concealing certain important material facts from the surety, and he is obtaining the guarantee. So you are misrepresenting the facts, or you're hiding the facts, and you're obtaining guarantee, then that guarantee is invalid. This can be asked as a short note. You have 142, 143 and 144. So that can be asked as a short note. The difference between contract of indemnity and contract of guarantee is also very important for exam. Okay, weightage around 4 to 5 marks. The difference between can be asked in the exam. So what is the difference between contract of indemnity and contract of guarantee? In a contract of indemnity, you have only two parties, indemnifier and indemnity holder. But in contract of guarantee, you have three parties, debtor, creditor, and surety. In contract of indemnity, you have only one contract, that is between the indemnifier and the indemnity holder. But in the contract of guarantee, you have three contracts. You have the primary contract between the debtor and creditor, secondary contract between the creditor and surety, implied contract between the surety and the debtor. Here the liability of the indemnifier is primary, he has to pay. But in case of surety, it is only secondary, he will have to pay if the debtor defaults. In case of indemnity, the liability arises only on happening of contingency. In case of guarantee, the liability will arise only on non-payment of the debt. Indemnity is a compensation, guarantee is given so that the person can secure loan, goods on credit, or job. You're giving a guarantee that this person will work with a lot of integrity, honesty, so that fidelity is guaranteed, and only then the other person is getting job. So that is the benefit of giving guarantee. In case of indemnity, all the parties must be competent to contract, but in case of guarantee, you are allowing the debtor to be a minor. It's still a valid contract of guarantee. All the liability will fall on the surety. Next, we have the nature and extent of surety's liability, section 128. This is a very important section for exam, very important. The liability of the co-surety is, liability of the surety is co-extensive with that of the principal debtor unless otherwise provided in the act. What does it mean? It means that whatever is the liability of the debtor, that exactly is the same liability of the surety. If the debtor is liable for the principal, interest, expenses, the surety is also liable to pay the principal, interest and other expenses. So it is same. The liability is secondary. This is section 144. So 142, 143 and 144 make the guarantee invalid. 142 talks about misrepresenting the facts. 143 talks about concealment of the fact and obtaining guarantee. 144 talks about when failure of the person to join as co-surety. Okay, it is the example that we are discussing is the same. It is applicable there also. 144 talks about failure of the person to join as co-surety. Now, the bank agrees to give loan to X provided he brings guarantee. So X went to Y. Y agrees to give a guarantee on the condition that Z should also join as a co-surety. I will give guarantee provided Z also signs. Y signs, but Z does not sign. Now, in this case, I had imposed a condition that I will be liable as a surety provided Z also signs the document as a surety. Now, Y signed the document, but Z fails. So, since the condition was not satisfied, the guarantee of Y is also not valid. Failure of a person to join as co-surety will make the guarantee invalid. So 142, 143, 144 talks about invalid guarantee. Surety's liability continues even if the principal debtor has not been sued or is omitted from being sued. What is the meaning of this? Now, there is a contract between debtor, creditor, and surety. The creditor may choose to file a case directly against the surety. Surety cannot refuse. Surety cannot say, oh, you should have first gone to the debtor, then you can file a case against me. I am very confident that the debtor is not capable of paying. Why should I waste time? So you can directly file a case against the surety. Surety will have to pay. Surety cannot deny. Once the surety pays, it can recover the money from the debtor. Next, we have the different types of guarantees, and one we have is specific guarantee, which applies to a specific contract. Contract is over, guarantee also comes to an end. Next, we have continuing guarantee, which is actually important for exam. Specific is hardly asked. Continuing guarantee means guarantee which applies to a series of transactions. Okay, it applies to a series of transaction. You can put an end to continuing guarantee by revocation. It is not applicable only to one transaction. It applies to a series of transactions. Now, one very good example that I can think of is that bank agrees to give loan up to rupees 5 lakh to X. He says, I will give up to 5 lakhs. So first he gave 1 lakh rupees. Okay, and let's also bring in a surety. S acts as a surety. So the bank agrees to give him loan up to 5 lakhs. So first he gives 1 lakh, then he gives 2 lakhs, then he gives another 1 lakh. Okay. So these form a series of transaction. Each amount given is a separate contract. Now S realizes that I don't want to continue as a surety. So he revokes. He said, enough. Now I am not going to give guarantee. So after he revokes, guarantee comes to an end. In spite of this, if the bank gives the remaining 1 lakh, for this, the surety is not liable. But what if X defaults in repaying the amounts which are given before the revocation? For that, the surety is liable. For the amounts given before revocation, if there is a default, surety is liable. But surety is not liable for any transaction after revocation. How is a continuing guarantee revoked? So revocation will happen by notice. So I gave a notice and I revoked the liability. It can also happen by death, section 131. Please note students, 130 and 131 both are very important for exam. In case of death, the surety's liability is automatically revoked. Okay, but yes, his estate is liable for the transactions before death, but his estate is not liable for transactions after death, after his death. Now, debtor, creditor, and surety. Surety has died, but his estate doesn't have any money. His estate doesn't have enough money to pay if the debtor defaults. So, if the surety is not able to pay anything, then debtor will have to pay the full amount because it is his primary liability. If the estate of the surety can pay only 50%, the remaining 50% will be paid by the debtor because it is his primary liability. There are various other modes of discharge. You have discharge by novation. You are entering into a new contract without the consent of the surety. See, in case of discharge, the surety is discharged because all these things are happening without his consent. Okay, all these things are happening without consent of surety. That is why he is discharged. Novation, you are entering into new contract in place of the original without my consent. Surety is discharged. By variation, this is nothing but alteration. You are altering the terms without my consent. I am discharged. Section 133, very, very important for case-based question. You are changing the terms. But ma'am, is he liable for the transactions which were incurred before variation? Yes. But he will not be liable for transactions subsequent to the variation. Then we have section 134. By release or discharge of the principal debtor. See, if the principal debtor is released, if the principal debtor is discharged, he is not liable. Automatically, his surety is also discharged. So let's say that the creditor has discharged the debtor. If the debtor is no longer liable to perform, the surety is also discharged. Section 135 is by arrangement. If the if the creditor without the surety's consent, okay, the creditor without the surety's consent compounds, that is, settles the amount with the debtor. He gives more time to the debtor. I had mentioned in my lecture, more time is given to the debtor on request of the debtor, then the surety is discharged. But if more time is given at the request of third party, then the surety is not discharged. If the creditor promises not to sue the debtor, if you're not filing case against the debtor, then the surety is also discharged. This is also very important for exam. Section 137. You need to learn this sentence by heart. Mere forbearance on the part of creditor to sue the debtor or to enforce any other remedy against the debtor will not discharge the surety. So like I have time limit of 3 years. Now it's only 1 year, but I have not filed case against the debtor. Doesn't mean that the surety is discharged. Surety, even if the main debt becomes time barred, you are still liable to the creditor. You will pay that time barred debt to the creditor. See, the main debt has become time barred. Your contract has not become time barred. So even if the main debt becomes time barred, surety will pay the money to the creditor and then later on he can recover it from the debtor. Creditors act or omission impairing the surety's eventual remedy, section 139. The creditor has done something, because of his act the debtor is discharged, automatically the surety is also discharged. Okay, now there is a difference between 134 and 139. Okay, in 134, first the debtor is discharged, therefore the surety is discharged. But in 139, the creditor has done something which directly discharges the surety. So in 139, surety is discharged. We are not waiting for the debtor to be discharged. This is the difference between 134 and 139. So in 134, first the debtor is discharged, then the surety is discharged. But in 139, the surety is automatically discharged because the creditor has done something which discharges the surety. Then we have loss of security. The debtor had given some security to the surety, so to the creditor. Okay, debtor has given some security to the creditor and he has also given some guarantee. Now the creditor either loses or parts with the security without the consent of the surety. Now let's say for example that the debtor had given furniture as security to the creditor along with some guarantee. The creditor returns the furniture saying, no, I don't want any security. Let's say the value of furniture was 40,000 and the guarantee given was for 1 lakh. Creditor, the debtor had given you security, right? Why did you return that? Now the debtor has defaulted. We had given you some security. You were very over smart. You returned that security. The surety's liability will be reduced by that amount of security. Now you can recover only the remaining 60,000 from the surety. If you lose the security, you lost the furniture worth 40,000. The surety's liability is reduced by 40,000 and now the surety is liable only for remaining 60,000. Invalid guarantee I have already covered. Then we have rights of surety. See, the surety has contract with the creditor as well as debtor. Because the surety has a contract with both the parties, he has rights also against both. The first is right against the debtor. He has a right of subrogation. What does it mean? Subrogation means to step in the shoes of the other person. The surety will pay the money to the creditor if the debtor defaults. So first the surety will pay money, then recover that from the debtor. Now when the surety is going to recover that money from the debtor, can I say he is also acting just like a creditor? He has stepped in the shoes of the creditor. So the surety first pays the amount, then steps into the shoes of the creditor and recovers that amount from the debtor. This is the right of subrogation, to step in the shoes of the creditor, some other person. He also has the right to be indemnified for all the money that he has rightfully paid to the creditor. So he can recover principal amount, interest, other expenses, whatever he has rightfully paid to the creditor, he can recover all that from the debtor. So surety has a right against the debtor. But surety can claim reimbursement only when actual payments have been made and not when he has merely executed promissory note. He's a very smart surety. Now, the creditor went to the debtor defaulted. So the creditor went to the surety. The surety, instead of giving him money, gave him a promissory note that I will pay. Then after a month, he recovered money from the debtor and then honored the promissory note and paid the creditor. Law says you cannot execute a promissory note and recover money from the debtor. Debtor is liable only when the surety has actually paid money. Otherwise, surety is very smart. He is recovering money from the debtor and paying it to the creditor. That's not why we took guarantee. Debtor was not capable of paying. That is why he requested the surety to act on his behalf, right? So you cannot recover money from the debtor and then pay it to him. You can recover money from the debtor only when you have actually paid the amount to the creditor. Surety can claim even if he has paid a time barred debt. Now see this. Debtor, creditor, creditor, surety, surety and debtor. So the creditor fails to pay the amount, debtor fails to pay the amount to the creditor. It's already 3 months, 3 years. This debt has become time barred. The creditor cannot recover money from the debtor because debt is time barred. But there is no time barred debt over here. The creditor can recover money from the surety. So surety will pay because there is no time barred over here. So surety will pay, but and then the surety can also recover that amount from the debtor because here also there is no time barred. So in case of time barred debt, the creditor can recover money from the surety and then the surety will recover that money from the debtor. So surety can claim even if he has paid a time barred. The main debt has become time barred. The secondary and implied contracts, they are not time barred. So surety will pay and then recover. Similarly, the surety now has rights against the creditor also. Like he had rights against the debtor, he has similar rights against the creditor. He has a right to the securities. Like I explained earlier, the debtor gave security to the creditor. The creditor loses those security. Then the surety's liability will be reduced to reduced by the extent of the value of security. Right to claim set off. Now, the debtor has to pay 50,000 rupees to the creditor and he has to recover 10,000 from the same creditor. Now, you get a set off when you have to pay and receive money from the same person. So, in this case, the debtor's liability is reduced to 40,000. Since it is reduced, this benefit will be given to the surety also. So, surety's liability will also be reduced by 10,000. Right to share reduction. Now, the debtor has become insolvent. He is giving only 25%. So, the debtor must have paid some money to the creditor. Let's say that the creditor had to recover 50,000. So, he got 12,500 from the debtor. Now, he has to recover only 37,500. So, this debt has reduced, right? The creditor has already recovered some money from the debtor. Now only balance is outstanding. So the surety's liability also reduces from 50,000 to only 37,500. Now what is co-surety? Co-surety means when the debt is, this is very important for case-based. Nowadays they are asking new questions, new case-based questions on co-sureties. Now A has given 50,000 to B. B provides guarantee of X and Y. Now, when there are two or more than two sureties, then they are known as co-sureties. Law says that for us they are equal. So, the liability is equal. Okay. Now, if there is some ratio that they have decided, so the loss will be bared in that, it will be borne in that ratio. But if no ratio is decided, then they will bear it equally. For us, they are all equal. See, I have examples also. PQR are sureties to S. Okay. So PQR, they are sureties to S, the creditor, for 6,000 lent to T. So they are all equally liable because nothing is mentioned. So they are all liable for 2,000. But what if they have mentioned that PQR, they are sureties to S for 4,000 lent to T. P and Q, they are liable for 1/4. R is liable for 1/2. So out of 4,000, P's liability is 1/4. Q's liability is also 1/4. R is 1/2. Okay, so this is how they will bear the liability. PQR are sureties to S for different amounts. It means they have limited their liability. P says, whatever be the default, I will pay only 10,000. Q says, whatever be the default, I will pay only 20,000. R says, whatever is the default, I will pay only 30,000. So they have set a cap that this is my maximum liability. Now the default is 15,000. So first, all of them will bear it equally. For us, all are equal. So first you will divide the default equally. Okay, the default will be shared equally subject to the maximum. Yes, it is within the limit. So now they will bear 5,000 each. What if the default is 40,000? First, divide it equally. It's an odd number. The maximum is 10, 20 and 30,000. So I will not pay more than 10, P says. So even though his share is 13,300, he will pay only 10,000. Okay, so we got 10,000. So out of 40,000, we are able to recover 10,000 from P. The remaining will again be shared equally. So we divide the default equally. Whatever is received from P, after deducting that, again we will divide equally. Now this is also within the limit. So P will bear 10,000, Q 15,000, R also 15,000. So in this manner, each co-surety will bear the liability. They may know each other, they may not know each other, they may enter into a single contract, they may have different contracts, that doesn't matter. For us, all the sureties are equal, they will bear the liability equally. A theory question or a case-based question can be asked on co-surety. And with that, we come to an end of our revision. So we revise the entire part on contract of indemnity and guarantee. Okay. In my next part, I will be revising the contract of bailment and pledge.